What happens if there's a refusal of the chemical test, a breath test or a blood test? When a law enforcement officer arrests somebody for suspicion of operating while intoxicated, they have the right to ask that individual to take a breath test or a blood test. If that individual refuses, then there's going to be a penalty for that. First, the person is entitled to a hearing to make a determination as to whether there was in fact a refusal. That is going to be done at the Department of State. If a hearing officer determines that there was a chemical test refusal, that will result in a 6-month license suspension without any restriction. So the question is, what can be done about that? Well, the circuit judge in the jurisdiction in which the individual resides does have the authority to issue restricted license privileges under a hardship basis. So what we can do is file a petition in the circuit court and ask that circuit court judge and explain to them that there is a hardship and that the individual is not going to be a danger to society, to the public, or to the roads when in fact that they're driving. Sometimes a circuit court judge will require the use of a breath alcohol ignition interlock device. But a majority of the time, that circuit court judge, provided that we show them that there is a hardship and that the individual will drive safely, will provide restricted driving privileges for that 6-month period of time.